Ladies and gents. So we're going to go into a session which is pretty topical right now and getting an awful lot of noise out there. What do the Google and Oracle shenanigans mean to the Java developer? Now, we've got an expert panel here. I'll introduce them. Starting at this end, Stephen Colebourne. Stephen, do you just want to say who you are?
Hi, my name's Stephen Colebourne. I wrote a few blog posts about Oracle and Sun versus Apache and the lawsuit, which is kind of part of the baseline which resulted in this particular lawsuit.
And then Ted Neward.
My name's Ted Neward, and I'm probably the least expert on this panel.
But the most opinionated, I hope.
And Martijn Verberg.
Hi, I'm Martijn. We have a seat on the Java standards body, and therefore we have been forced to look at the legal implications of this particular lawsuit.
And Ben Snipe.
Hi, I'm a patent attorney. I do a lot of work with tech patents, and so I'm here as the so-called legal expert.
We have a lawyer, folks. We actually have a lawyer. Woo!
Okay, Martijn, I'll hand over to you. Do you want to just ask a few questions? This is going to be quite heavy audience participation, and so I'm going to run around. Put your hand up if you want to say something. I'll try and get to you with the mic so that we can all hear. And aside from that, I'll hand over to Martijn.
So just a quick question. Who's here to just quietly do some coding in the back of the room? Good. Who here has absolutely no idea what the session is about? Great, Ted, brilliant. So we'll probably have to do a little bit of a summary. That's good. How many people here have actually got burning questions? So we're going to have to entice questions out of you. Okay, so I think what I'll do is I might actually hand over to Stephen, who can explain the deep, dark history of where this all began. And we will then sort of either maybe have myself or Ben sort of explain what the current ruling is and why everybody on the internet is scared. So on to Stephen.
Wow, that's a big topic. So, way back when Java first came out, perhaps before some people in this room were born, Java was this wonderful new programming language. And you could have the source code, and it had a specification. But that source code was not open source. You could see the source, but it was not open source under a recognized open source license. And when Java first came out, there was a specification, but it was not really what you'd consider to be an open specification, i.e. one that somebody else could go off and implement their own implementation of Java. Now, this mattered to a few people back then because, like, C and C++ were open specifications. You could go off and implement your own version of those things. But Java wasn't. So a few people got upset by this. And so Sun said, well, yeah, we'll make it an open specification. Why not? And so they went away to ISO, thought about it, decided not to. They went away to the ECMA group in Europe, decided, nah, we don't feel like doing it there either. And so what they did instead was they set up the JCP, Java Community Process, which is a department within Sun Microsystems. Back then, now a department within Oracle Microsystems. It's not an independent standards body. It makes itself out to be an independent standards body on occasion. It could produce standards which could be treated as independent standards, but it is fundamentally just a department of Oracle. So, great. You know, now we've got this thing which is capable of producing things which we can treat as being open standards. And so Java SE, the version that we all go out there use, Java SE 4, 5, 6, 7, there is an actual JCP organized standard, a JSR, and, you know, like there's a JSR to define what servlet specification is, or like there's a JSR to define what JAX-RS is, there's a specification which defines what Java SE is and what the virtual machine does. Great. Since there are multiple people who can go out there and implement JMS, multiple people who can go out there and implement servlets, there must be multiple people who can go out there and implement Java SE, mustn't there? Ah, well, yeah, but no. You see, what actually happened was Apache did a deal with Sun Microsystems to say, yes, we can go out and implement all these various specifications. Great. Then they came along and actually implemented Apache Harmony, and Sun didn't believe that they would ever be able to implement the Java SE spec. And Sun decided, having implemented the spec, they really, really, really didn't want you to implement the spec. And so Sun Microsystems went in a little closed room with their lawyers, and they basically found a back door by which they could block Apache Harmony. Right, so that's Apache Harmony. What's got anything to do with Oracle and Google? Well, you see, Android took the source code of Apache Harmony and used that to make Android. There's a connection. And that connection is an interesting one from my perspective, because the way Apache views it, I used to be a member of the Apache Software Foundation. The way Apache views it is that even if Apache had got certified as being an official Java SE implementation, that would have been insufficient to cover Google using that implementation in Android. Because as soon as Google made any single change to any single file, Google would need to have been certified. And what were the chances of Sun giving Google certification rights? Well, that involves money, because that's about money and power. Sun needed the money. Google weren't willing to pay them, so Google went off and said, well, we don't think anything's going to happen here. Then Oracle took over Sun, and well, Oracle decided they weren't so fussed about the money, they're rich enough as it is, but they do care about power. They want the power over the Android ecosystem. And well, they're not going to give Google the rights to certify Android or do anything nice about Android anyway. So it's a long and sordid tale of money, power, big corporate politics, and shafting Apache Software Foundation. Not that I've heard of, but you never know. Sadly, this isn't a terribly gender-equal industry.
Wait, no sex? Fuck, I'm out of here.
Come back. Martijn.
Going back to the G-rated show. So Oracle, some time ago, basically took Google to court, claiming that they had copied verbatim a set of APIs from Java directly in order to create Android. Now, the Oracle lawyers went on several fronts, looking to see if there was a patent violation, looking to see if there was copyright violation, so on and so forth. The patent argument got thrown out the window fairly quickly, and in the very first ruling by a Judge Alsop in the US courts, said that the APIs are also not copyrightable. And that was kind of done and dusted, and everybody went, okay, Google kind of wins that round, and they're going to carry on as normal. But of course, as these things go, the lawyers appealed. And so they went up to the next level of courts in the US, which is the Circuit Court, a District 9 Circuit Court, which doesn't cover all of the US, just sort of a part of the US. And that particular judge reversed the copyright ruling that the first judge had made. So this new judge had basically said that APIs are actually copyrightable. So in sort of Java developer terms, that method that you have to add two numbers and get a number back, so the design of that API, as it were, this judge believes that is a copyrightable thing. This is the first time any judge in a US court has actually stated this as a legal ruling, and this is kind of why the software industry, not just Java developers, are quite concerned. What it potentially can mean, this is what people are scared about, is that if you use an API in a compatibility layer, for example, let's say if you are the Mono project and you're trying to implement .NET on Linux, and of course you want to be API compatible with .NET because that's the whole purpose of what you're actually trying to do. In theory, Microsoft could now turn around and sue those people into the Stone Age. This is the current fear. Ben, would you like to add anything to this further?
Sure. To me, it's just perfectly obvious that there is copyright in APIs. The way the court looked at the APIs is they broke it down into the declaring code, which was copied line by line by Google, and for which, just like there's copyright in a book or anything like that, it's just perfectly obvious there's copyright there. And copyright law in part exists to protect software developers. So really, it's quite correct, and you should be happy that, some might say, the copyright law applies to this to the declaring code. Now, the court broke down the API into, as I said, two parts: the declaring code and the other bit. The declaring code is the literal bit, and there's the non-literal bit, which it called the structure, sequence, and organization of the API. Now, with things like this, it's always a bit more difficult to know whether there's copyright inherent in it. The way US courts look at these things is they consider a kind of sliding scale where you've got concrete expression at one end and really abstract ideas at the other end. And the structure, sequence, and organization of an API kind of falls somewhere in between those two extremes on this scale. And it's a matter for the court to decide whether or not, whether the threshold is met. And it's kind of a judgment call on the part of the court, the threshold being as to whether copyright does exist in the structure, sequence, and organization of the API. And in this case, the court decided that copyright does exist in it. So there were two parts, the declaring code and the structure, sequence, and organization. Copyright exists in both. Google had just hijacked the whole 37 APIs belonging to Oracle and implemented them in Android. And in my view anyway, that's it's not really something that they should be doing. They were negotiating a license with Oracle. Other companies have negotiated licenses for those Java APIs with Oracle, and Google broke off negotiations, or the negotiations concluded, I should say. Just for the record, nothing I'm saying constitutes legal advice. I think the judgment is perfectly correct. You want to have a go?
Hold on, Mark's got the mic.
Just a very quick one. Is it, when you talk about US copyright law, is it going to be noticeably different here in Europe or the UK?
Probably not.
Because apparently we took over your court system too. We're America, right? That's what we do. Mark, there's a question here. Yep, wait for the mic because that way it gets picked up by the recording equipment, and that way all the viewers at home can hear your question as well.
I thought that with the exception of Louisiana, who used the French system, we sent our system over to you.
But we fought a war and kicked you out. Anyway, I mean, apparently we've migrated to world history now. I don't know. One of the things that we want to be really clear as we look at this is there's a lot of things that are all tangled up, a lot of emotional things that get tangled up in this, and we need to start with the basic premise that copyright is in fact a good thing. If you don't believe copyright is a good thing, then obviously this entire discussion you're going to be very upset. We need to agree that intellectual property protection is a good thing. And one of the reasons why this particular case has so divided our industry is because a lot of the big money-making corporations have actually come down on Oracle's side, because if I can in fact take your code and copy it line for line and use it without paying the appropriate license fee, whether that's simply attribution, whether that's I need to give you money, whatever you have decided is fair compensation for the use of your intellectual property, if you take that to its logical extreme, it really devalues a great deal of what we do in the industry. And I don't know about the rest of you, but I do like getting paid for what I do. That's the far end of the, sort of the corporate side, the Oracle side of this particular argument. And that is a deep-seated fear. On the other side, the open source community is very right to point out that, look, Oracle has never met a licensing plan it didn't try to implement. And if Oracle somehow can come out and say the use of these APIs is in fact something that's subject to license, then we could all wake up one morning and Larry Ellison is knocking at your door and saying, all right, you now owe me $1 million because I have just changed the rules out from underneath you. And then we'll all have to go off and write Perl. And God, none of us wants that. So there's, and that's another deep-seated fear. And so we kind of need, if we're going to have any sort of reasonable conversation about this, we kind of need to step away from some of those emotional reactions that get brought up as a part of all of this and try to be the logical and analytical creatures that we're supposed to be and say, what does what you're asserting really mean without going to either of the emotional extremes? It's hard sometimes, but I think to be fair, we have to try to do that.
So I guess a key part of what this was trying to be was to be a separation between the specification side and the implementation side. That's why I started by focusing on those open specifications. What you should have is an open specification that specifies what the code does. Now, in Java's terms, that means the Java doc of everything in java.lang, java.util, java.io, etc., but none of the implementation code. Now, if you have the specification, the Java doc, and the method signatures, and you want to go away and implement that code yourself, that's what the specification is meant to allow. So the question is that specification copyrightable? Now, the reason why the JCP exists, the reason why specification bodies exist in a key part is to provide a mechanism to allow the IP to flow from the person who created it to you who wants to implement it. The JCP has a defined mechanism by which that intellectual property to permit you to implement the interfaces flows from Oracle to you. There's a set of things you have to do. One of these things is, you must implement it according to what the specification says. Seems like a good thing. And another thing is that you must pass what's called the TCK, the Technology Compatibility Kit. Again, seems like a good thing that the code you write should actually do the same thing according to the tests as what the original implementation does. Seems like a good thing. Now, it's the licensing around the TCK, which is where Oracle came along and blocked Apache. And it's that same licensing as, Oracle have to effectively permit Google that, Google has to negotiate for a license and pay money in order to get the rights to implement that. Google eventually just basically went away and said, well, we're not fussed about being a compatible implementation of Java. We're a good enough implementation that we don't have to worry about it. But that means that technically Google never got those IP rights to flow across. So Oracle holds the IP rights. Google has got something which is implementing all of Java, implementing all the specification, to a 99% similarity level, but they never flowed the IPs across. Because they never flowed the IPs across, there's a lawsuit.
I'm not in the panel, so I'm definitely not a lawyer, and I don't understand much about all those things. The only thing about copywriting is, at the end of the day, we don't do a lot of magic. We just use a language. And I remember Richard Stallman giving this image that struck me. Music is a language. Imagine if someone would have said, EAD, that's a sentence, and I'm going to copyright. We will never have blues music. So, we just write sentences. Why can't we just copy-paste Java bits like we do with music or we do with English literature? Or, why is there this copyright thing in IT? You're just using a language.
But everything you just said, in fact, is copyright. The music industry is all about copyright. You cannot take Britney Spears, because you look like a Britney Spears fan. You cannot take her music and perform it on stage and charge people for the fact because she wrote that song, she strung those notes together in that particular order, she owns that particular tune. And as a result, because she did all of the work, however work there really was, because she did all the work, she is owed compensation for the time that she invested in that. You do not get to stand up and wear a very skin-tight outfit and now, the interesting thing is, I mean, the same thing is true of literature. You're right, we all use the English language, and you cannot copyright the English language, but you can, in fact, copyright a particular sequence of words to a particular length, because if you were to take one of my articles, for example, on Oracle TechNet or on MSDN or on DeveloperWorks, and you were to copy-paste it onto your website and put your name to it, yes, you're going to piss me off. Because that was my work, and those were my words. And yes, it's the English language. And you can take those concepts, those ideas, and you can rephrase them in your own words. Absolutely, that's great. That's fair use. But you do not get to take my exact words and make them your own. These are the kinds of things that copyright was designed to prevent. You cannot take my presentations and give them as your own. You must offer fair use. You must offer attribution or whatever I choose, because I put the work in to make sure that the story flows the right way, et cetera, et cetera. Oracle is not trying to copyright the English language, right? They're saying this particular book, we wrote it, we put the work in, although technically that's not true. Sun put the work in, but we bought Sun. So it's as if we did the work. And you can't just take it verbatim and sell it as your own thing. So if we're going to do the analogy thing, let's at least make sure we're doing the analogy apples to apples.
Yeah, so I think what's interesting about this is that there's almost universal understanding that APIs and interfaces were not copyrightable over the last couple decades of the software industry. So there's been a lot of things that we don't have agreements in place where we would now need them. So for example, the people who have implemented JRuby, did they get a copyright assignment to implement Ruby? And the same with all the other third level languages. Did Oracle get copyright assignment to implement Nashorn, which is JavaScript? So these agreements maybe are not in place. In fact, I know they're not, at least in terms of JRuby and those types of J versions of previously existing languages. So those are APIs that were not considered copyrightable before. And so we have a situation that's sort of worse than patent war. We have a situation where we've all been very lax on this thing because we didn't think we had to protect ourselves legally because we thought we were in the clear, and now the rules effectively changed. And, well, all hell is going to break loose unless this ruling is somewhat adjusted. But the thing is that if someone buys the creators of, like, JavaScript, well, then they can sue everybody who's implemented JavaScript over the last several years. And it does really open up the doors for a little bit of Pandora's box.
So that's an interesting point. So I'm just going to raise a new concept that a lot of people haven't read about in this particular case. So the case has actually been sent back down to the original court because they're now going to discuss the concept of fair use, which is an incredibly wonderful, loose piece of terminology which basically allows people like Ben to have a living for a long, long time. So in the case of JRuby, or an implementation which basically has no other choice, no other means to fulfill its purpose, and as long as there's no commercial basis for that purpose, so the people behind JRuby aren't selling JRuby commercially, then in theory, under most case law I've read that is fair use in the United States anyway, would have actually deemed what JRuby have done as fair use and therefore will not fall foul of copyright law. Now, of course, I will say this is open to interpretation by lawyers, but that's generally speaking how these cases have gone before.
Well, the other thing I want to point out, you used the example of JavaScript, and in that case, JavaScript you couldn't ever sue because JavaScript is actually a standard. JavaScript was submitted to ECMA a number of years ago, so actually the formal name of the language is ECMAScript, where JavaScript is one particular implementation. Originally, that was the Netscape implementation. We actually do ourselves a bit of a disservice by referring to it as JavaScript, because we are talking about a vendor's implementation of the open standard language ECMAScript. Microsoft has one called JScript. Mozilla has one called Rhino, and Oracle has one now called Nashorn. So the language, again, this gets back to the specification implementation. The language has been spec'd, but as long as I don't take the Google code verbatim, copy and paste it, and then release it as TKN scripts, right? There's no issue there, right? The other thing that really complicates this issue, very bluntly, is that 99% of the time when I put something out there and you try to build an implementation of it on your own, that's actually helping me because it's getting more people to use the thing that I created. So in many cases where companies might have had a legal ground to say, don't do that, in fact, it benefited because now it's like, oh, yeah, go, you're making my thing more popular. Go do that. Absolutely. Go build that thing. But this is part of the reason why language specs are important. And this is part of the, this was some of the surprising things behind Sun's activity with respect to ISO and ECMA and ANSI, that they didn't submit Java as an open specification, because then some of these issues might have been sorted out 15 years ago.
Yeah, I just want to draw a distinction between what Google's doing with Android and the kind of thing that you might do typically with a Java API. If Google had made a Java client, for a Java-based Nokia or BlackBerry device, say they'd made a Google Maps client, then Oracle would have had no interest in suing them. Oracle when it publishes its APIs, it wants, as my colleague here was saying, it wants you guys to use the APIs, to use Java. It'd be commercially illogical for them to turn around and sue you. There's an implied license, if there's not a real license in their terms and conditions, when you use a Java API. And it would just be ludicrous for there to be any kind of infringement of Oracle's rights. Now, this kind of normal situation is entirely different to what Google is doing, where they've taken a load of the APIs and they've incorporated them in Android. I hope that is clear. Anyone else? There's a question?
Being held in my face. So in terms of where we are now, is it likely that Google is going to drop Java for Android and go with Dart or something because of this?
No. Realistically speaking, think about what that would imply, right? How much would have to change? How much they would have to, they would literally be rebuilding Android from the ground up. So I don't see it at all. I could see them saying, here is an alternative language for producing Dalvik bytecode, but we already do have alternative languages. They just happen to go through Java bytecode to get to Dalvik bytecode. You could do Groovy, you can do Scala, you can do all these other things. Personally, I don't think Oracle really wants to destroy Android. I don't think that makes any sense to them as a company. I don't think it makes any sense to them as the owner of Java. I just don't see it. Quite frankly, what I think Oracle wants, very bluntly, is to be a player in Android. Because if you look at the Oracle stack, that's the only thing they're missing from their full stack experience. So if they can come in, and if they can negotiate something with Google, to hell with the $1 billion, right? Larry blows that on a yacht, all right? Who cares? It's another fighter jet, whatever. He'll just raise Oracle licensing rates and get the money back. He doesn't care about the money, I don't think. I think what he wants is for Oracle to be a mover and shaker in the Android space, recognized by Google as being such. And I think if the two companies can kind of get past the, machismo, I own Java. No, I own Java. they can get past that. I think that they could actually work very well together once they kind of get past who needs who more kind of thing. And I just cannot even remotely see Oracle wanting to shut Android down. I don't see that they could possibly shut Android down, and I don't see that they could take Java away.
So I'd summarize it as Google have been dumb in allowing themselves to get in this position where their prime thing, Android, is under threat by and it was kind of done quite deliberately. They chose not to sign a legal agreement with some microsystems. They chose to go their own way. They chose to copy Apache Harmony. They chose not to have it through the JCP. So Google was dumb. Google was dumb again because it didn't buy Sun Microsystems. Dumb squared. But you see, Oracle was dumb as well in actually going after them via a lawsuit. Oracle, what has been the main driving excitement thing in the Java industry for the past 5 years or more? It's been Android, not Java itself. Java was dying as Sun Microsystem died. Android kept it going. So Oracle have been dumb squared by actually going off and trying to kill the one thing that's been keeping Java alive. Oracle doesn't know how to value Java. But hey, dumber, dumbest? Who knows?
And I will say that, and Ben, correct me if I'm wrong, but my understanding of patent and IP law is that if you do not defend your copyright and your patent, that is considered to be prior art and precedent. And again, the legal system, it's all about precedent. So if Oracle doesn't go after Google and say, okay, you're violating our patent, look, let's just, and I think in some respects, these big companies, one of the things you have to understand, I live in Redmond, Washington, so there's a software company very close to my house. Some of you may have heard of them. I won't name any names, but it starts with M and ends in Microsoft. I have a large number of friends who work for that company, and they talk about how they have patent Fridays, where Friday afternoon, after lunch, you go back to your office, and you think about what you've done, and you just start trying to write up patents. Because these things are, in fact, currency among the big corporations. Apple, Microsoft, IBM, they've all exchanged patents on the various things that they do, because that way it's, I'm not actually giving you money. I'll tell you what, I'll give you the patent for the round button on the screen if you give me the patent for the sort of rectangular-ish button on the screen. Sure, there you go, we're done. It's a currency amongst them. So I can easily see Oracle going to Google and saying, yeah, okay, let's just do this, right? Let's just have this conversation. You violated our patents, blah, blah, blah. Just give us some stake in the Android and we'll call it good. And Google going, no, because we're Google and we don't do evil. What are you talking about? Seriously, just sign the stupid paper so I can go home and have my 3-martini lunch. No. Seriously? You're going to, fine, fuck you, I sue you, right? I mean, I can just see that conversation happening out there in Mountain View, right? I can see the lawyers on both sides looking at each other like, we really don't want to be here, but...
Charge every 6 minutes.
Exactly.
Charge every 6 minutes.
Exactly, so that they can dress better than the rest of us. Do you notice this? Do you notice this? The point here simply is that I think in a lot of respects it's the arrogance of two very large corporations that is being aired out in the courtroom here, with all of this other stuff that we were talking about being sort of the political fallout, if you will. But there are some interesting and important, as was pointed out earlier, there are some important implications that are going on here. I don't think Oracle really wanted at any point in the game to destroy Android. It's just, you know what? If we don't go after these guys after they said no, then other companies, and there are trolls out there who would do this, other companies would do the same thing, and then that completely devalues the whatever billions we spent for Sun and all of the things that it owns. If Oracle doesn't make some kind of move here, they hurt themselves in the long run.
Ben, could you elaborate more on the distinction between the structure and organization of an API versus the textual representation of it?
That's the language that the US court used,
What does it
structure,
mean?
sequence, and organization of the APIs. Go on.
Yeah. So in Java terms, package structure, class structure, method structure. That's simple.
There's two things there, and one was there's two things. One was obviously copyrightable. The other one was maybe copyrightable. So what are those two things, and why are they different?
So one was actual implementation of classes, methods, interfaces, and the other one was how they were organized, so how they were structured in packages. Right.
By the way, guys, there's got to be a rhythm to these questions. Mark's significant other called me the other day. He's not getting enough exercise. So if the next question could come from over here, this way he gets some jogging in while we do this.
You're doing great, Mark. You're doing great.
I'm just curious, why isn't there a Google guy there in the panel to present the review? You all?
They said no.
In all seriousness, nobody from Oracle or Google will ever be allowed to comment on this case, and that's just normal corporation politics, etc. I mean, it's just standard legal practice, right?
So
I don't work for Oracle, just in case anybody was confused. I don't work for Oracle.
And to be very blunt, a good friend of mine, Brian Gatz, the architect of the Java language, even on a private email, Brian will not comment on the suit because, and I'm sure it's very true of Google as well, all of those employees have been dragged into a room much like this one and beaten over the head for 4 hours by lawyers saying, don't say a bloody thing. Because anything you say can and will be used against you in a court of law. And they're very serious about that. So even if there was an Oracle guy at the conference and a Google guy at the conference, there's no way they could come up here and talk about it. As a matter of fact, I don't think they could even talk about it in a restaurant that was empty. Nobody wants that.
We'll just check with Ben. Ben, would you allow one of your clients to come on a panel like this if they're involved in litigation?
Absolutely not.
And if the lawyer says it, it must be true. More questions?
So the legal process is still ongoing, right? The litigation is still...
Yes.
So how much longer? This is just an intermediate ruling, right?
How much money do you have?
No. Well, when can we expect it to finish?
The estimate I've been given from friends of mine who are lawyers in the US is probably about 5 years until it gets back up to the Supreme Court. And even then, it would still only be a USA ruling only. We, after all, are actually, in the rest of the world here. Now, some of the countries, especially in Europe, do follow American law, or close enough to it, because you've reverse invaded us. But, it still is a case of it's not going to be a universal law across the entire world, which is going to add even more complexity to the whole scenario. But I would say at least 5 years. I don't know about in the UK.
It's not started in the UK.
yet.
No, I doubt it will. I doubt it will start in the UK. I mean, it might, but I'd need one of two US companies to initiate UK court proceedings, which neither has, to my knowledge, yet done.
I was thinking along the practical implications, the fact that Oracle has just been revamping their mobile and embedded platform, and that Android has benefited from the fact that they were able to take certain technical optimizations with Delvik to optimize it for mobile in a way that works inherently differently from Java mobile and embedded. And if Oracle wins the case, can you see from a technical point of view how they can reconcile these two platforms if they've essentially got two competing platforms in the same space? They can kind of coexist, but they have to kind of reconcile them if they want control. I mean, sure, I agree with this whole mess could have been avoided if they just bought Sun or paid the licensing fees, and for good measure, they could pay taxes in the UK as well. That would be nice. But we are where we are. it'd be nice if they wouldn't be evil, but from a technical point of view, say, I see it being very hard to go now and trying to change Delvic and make it into Java embedded because they work in such different ways. Can you comment on how you think that would play out?
Let's assume the world was all rosy and Google and Oracle hugged it out in the law room. And then the two engineering teams would basically have to decide which one they would pick. Much like when Oracle took over BEA and there was the JRocket JVM and the Hotspot JVM. It's such a core part of the entire system, the entire ecosystem, that there can kind of really only be one. So you just hope they'll take the best of both worlds and have an ugly stepchild of the two, or hopefully a better looking one, I should say.
Hi, you mentioned, I believe the word was an S-storm of lawsuits following this up. Has there any evidence of other companies pursuing people who have been doing similar implementations of their APIs, or is this just the first one of these?
It's actually a counter example. I will note that Microsoft and Xamarin have had a number of deep discussions around some of this, because that was used as an example earlier. And again, nobody at Microsoft will go on record as saying one thing or the other, but the word that I've received through the people that I know there is that Microsoft, they love Xamarin. They want in no way, shape, or form to try to shut those guys down. There's actually been some rumors of acquisition that they would love to buy those guys, and because they're doing they're doing a kick-ass job, quite frankly. But I do know that Microsoft has actually been following this case very, very closely, for starters because finally somebody wasn't suing them, but because this does have some deep implication, as was mentioned earlier. This does have some deep implication for some of what they're doing and how they're going to interact with the rest of the world and so on. I think as a company they're in kind of a wait-and-see mode, because at this point, at this point, it's probably Oracle up by a couple of points, but that doesn't mean that that's how this is going to end. And so before you start making any real long-term plans, I think you want to see how this thing goes. If it goes back to the Supreme Court, it drops down to the district court, and then it'll go up and then up, and will it reach the Supreme Court? What will be the composition of the court at that point? Will it be considered more pro-business, or will it be more IP-oriented, more liberal? There's so many wild cards here that I think a lot of the companies in this particular situation, they may be quietly rewriting their license agreements just in case, but I don't think anybody's taking a public position just yet. I haven't heard of anything, either Microsoft or Amazon, both of which obviously are in Seattle.
I mean, that's the thing. You go to lawsuits and a bit of a crapshoot, really, isn't it? You don't really know. It is up to lawyers and judges to talk about things and trying to decide, well, where on this grey scale between black and white is it? And it's like, does Oracle really know whether it's going to be a yes or a no? Does Google really know whether it's going to be a yes or no? No, neither of them do. Nobody does. It's kind of in their interest to never have got started. The problem is now they've got started. If they all quit and settle now, I'm assuming that the world of the courts and the world of the law will assume that APIs are copyrightable. So Google can't stop now. And if Google gets it reversed at the next court, then Oracle can't stop. And so on all the way up to the top. We're stuck in this hamster wheel train now. It's kind of like we can't escape.
What will happen? Let's say that Oracle wins tomorrow or in 5 years, whatever. What will Google have to do, or what are Google's options, and what are the implications for Android users and developers?
Pay money?
I think they're going to have to cut a license deal, to be very blunt. I think Oracle's going to say, give us a seat at the Open Handset Alliance, which is technically the group that owns Android, and give us a seat, and pay court costs and whatever damages the court finds and whatnot. But I think at that point, it's done. It moves on. The bigger issue is the issue of, are APIs considered copyrightable? Are they not considered copyrightable? Are parts of them copyrightable? What constitutes an API spec, right? So if I go, for example, look at Joda time, and here's the Java doc, is that in fact considered a spec? And can I write my own implementation to that spec, or is that not yet definitively considered a specification? There's going to be a lot of technical interpretation that's going to happen before we can really, I think, answer that question in full.
Yeah, I think that APIs will remain copyrightable. I think the issue that remains to be decided is really about fair use of the APIs. And it remains to be seen what the US courts will have to say about that. I suspect that Google will settle. I doubt it will continue to the Supreme Court. It may do, you never know, but I suspect Google will just hand over some money and the issue will die until somebody else wants to raise it.
Okay, sometimes in these lawsuits, especially, for example, the recent EU lawsuit over sort of copyright and caching and things like that, as a layman programmer, you get an impression that a lot of the problem is that the judges and the lawyers don't really understand the exact technical issues that are at stake. Do you think that's the case? I get the impression listening here that that's not so much the case in this lawsuit, that they do have an accurate understanding. Do you think the judges and the lawyers do have an accurate understanding of the technical issues, or that they...
I think generally, especially in the UK and also largely in the US, judges and lawyers have an excellent understanding of the technical issues. In the UK, the lawyers are specialist lawyers, the judges tend to be specialist judges. In the US, the judges will also have, in these kinds of cases, will have good experience of, good knowledge of technical issues. What can be a problem in the US is for patent and copyright disputes, they still have jury trials. They don't just use specialist judges, and it can be quite difficult to impute onto a jury all the technical issues as well as all the legal framework. But with the actual judges and lawyers, I don't think there's really a problem. I think judges are bright people. You can make them understand the issues.
The other thing to remember here is that the 9th District Court, guess where that covers? The Silicon Valley. The 9th District has seen a lot of these kinds of cases. And so a lot of the judges, remember, a judge has a complete staff who are going out and looking at previous briefings, they're assembling briefings, they're doing a lot of the research. So it's not just what the judge knows, it's also the summation of what his staff knows. And bear in mind that, of course, both sides are submitting expert testimony that supports each, corresponding position, et cetera, et cetera. And let's be honest, right? Judge doesn't have to know how to write Ruby to understand, a lot of the concepts that are going on here. I know that we kind of like to assume that what we do is a dark art and black magic, and only the best can really understand what we do. Only the extremely smart, the incredibly handsome. Anyway, but the fact of the matter is that a lot of this, a lot of these concepts, a lot of these ideas have been around since, since writing. Shakespeare and whatnot, and okay, dude over here is putting on a Shakespearean play, go kill him, right? Because that's my play. The 9th District has seen a lot of these. The whole IBM antitrust suits, a lot of it went through 9th District. The Sun v. Microsoft cases, a lot of it went through 9th District. So this is not their first rodeo. I'm sorry, rodeo. Do you have that in the UK? This is not their first tea party.
2 minutes left. So we've got 2 minutes left, so I'll probably just get everyone on the panel to sum up their views in about 15 seconds. We'll start with Stephen on the left.
Dumb, dumber, dumbest.
Evil.
Nothing to see here, move along.
Yeah, hot air, keep coding.